Conflict or disputes can easily arise with our dealings with the various government agencies at local, state and federal levels. You could find yourself in a dispute over a tax refund, a decision to impose conditions on a licence, or a decision by Centrelink to cease giving you payments. These decisions that I've just mentioned are all administrative decisions. And if you want to challenge administrative decisions, you need to use the administrative law. Any administrative decision of a government official, authority or department, or anyone exercising public power can be challenged through administrative law. The rule of law is particularly important in this type of dispute because it needs to ensure that the government is not in a superior position and that we are all on a level playing field. There are a number of legal and non-legal methods used to resolve disputes with the state, but today I'm going to focus on the legal options. I think the best way to discuss the available methods of dispute resolution is by considering a hypothetical situation. Imagine that you've applied for a passport and it's been denied. What can you do? In general, the main options for review of a decision like this include internal merits review, external merits review, external judicial review, or a complaint to the relevant Ombudsman. Merits review is a process by which a new decision is made. In general, it requires that an individual remake the decision after consideration of the facts. This person that makes the decision will then substitute what they believe is the correct or best decision. The legislation or regulations needs to identify who has the power to conduct the merits review. For example, the review may be conducted by a more senior official within the decision-making organisation, a minister, a specialist tribunal, or an independent tribunal such as the Commonwealth Administrative Appeals Tribunal. The power to review the decision not to issue with the passport may be reviewed on its merits, both internally or externally. The legislation provides for both of these. The Minister or a more senior official of the Australian Passports Office who has been delegated the Minister's power can conduct an internal review. The process for this is set out in Section 48B of the Australian Passport Act 2005. Without a provision for internal review in the Act, the decision was made under, there would be no right to have internal review. In our passport scenario, a tribunal, the Administrative Appeals Tribunal, or AAT, would be able to provide external merits review. We have the power to seek this review due to Section 50 of the Australian Passports Act. As discussed in Part 1 on disputes between individuals, there is an increasing trend towards the use of alternative dispute resolution strategies. And in this case, we would have to use an alternative dispute resolution mechanism because a dispute that goes to the AAT has to be referred to a conference, which is a meeting conducted by a tribunal member or an officer of the tribunal, which the parties have to attend. The decision not to issue us with a passport would be a decision where you would have the right to seek external judicial review by the Federal Court or the Federal Magistrates Court. The power to do this comes under the Administrative Decisions Judicial Review Act of 1977. Judicial review is the process of review by a court of a decision or a failure to make a decision on the grounds of its lawfulness. The court will not consider if the decision was correct or right, as you would in merits review, rather they consider the process. In determining the lawfulness of the decision not to issue the passport, the court will consider whether the prescribed process has been undertaken. For example, the decision maker may be required to investigate certain matters or also produce various forms and documentation. Complaining to an ombudsman, who is an independent person who investigates the complaints from citizens or consumers about agencies, departments, or service providers, is often viewed as a last resort. If the other dispute resolution mechanisms have failed us, in our passport example, we could complain to the Commonwealth Ombudsman. However, it's probably ineffective in that it doesn't give us a result of compensation or having the decision remade. It is essential under the rule of law that in disputes between the individual and the state, that the individual still ranks as highly as the state. In Australia, there are numerous measures to achieve this. One such measure is that the government must act as a model litigant. This ensures that the rule of law is respected by not allowing the government to utilise its significant power imbalance. The model litigant rules are contained in Appendix B of the Legal Services Directions, 2005, which are issued by the Attorney General. In essence, these directions require legal representatives to exhibit complete propriety, fairness, and conduct of the utmost professional standard, both before the court and during the conduct of all of the matter. In further recognition of this power imbalance in favour of the state, there are often clearly structured procedures in place to enable an individual to contest or review a decision by the government agency, both internally and externally. All these things act to protect the individual and as such uphold the rule of law.